gentlemen. Thank you for tuning in. Hope you are having a pleasant day. It's great to be back again this week with another episode of the Strata Talk Show. With that, I would like to welcome everyone to the 40th episode of the Strata Talk Show, brought to you by the Excel Academy of Real Estate. In this talk show, we'll be discussing issues and cases related to the management of stratified developments with various industry professionals. Joining us today, we have Mr. Leong Chee Weng, who is a partner of Tuang, Chu Co, advocates and solicitors, to speak on the topic of liquidated ascertained damages, also known as LAD. If you have any questions for Mr. Leong, feel free to leave them in the Facebook comment section below, which will be addressed in the Q&A section at the end of the show. Without further ado, join me in welcoming Mr. Leong. Welcome, sir.
Thank you, Nafa, for the kind introduction. First of all, I'd like to welcome everyone who's tuning in. Before I start, I would like to just take this opportunity to wish those who are celebrating a happy Chinese New Year. Thank you for taking the time to attend this topic, which I think most of you can relate to, which is liquidated ascertained damages, which is LAD. Now, of course, first of all, I also like to take this opportunity to thank Excel Academy for the invitation to share on this topic. Now, why I say LAD is a topic that everyone can relate? Well, I think most of us is going to be a home buyer or is a home buyer. And as a home buyer, you want to know your rights in the event where your developers delay in giving you your vacant possession. What are your rights? What can you claim and what you cannot claim? That's where LAD comes in. Of course, some of you may be in the construction industry. You may be a contractor, you may be a developer, and you would also want to know what are your risks and what are your rights in the event that the construction of the project is delayed. So without further ado, let us begin. Now, these are the three topics that I intend to cover today. First of all, what is LAD? You hear it a lot. LAD, I'm going to claim LAD, but what exactly is it? Is it provided under the law? Is it something that you can claim as of right? So long as there's delay, I can claim as of right? Or is it something that, you have to agree between the parties? And then after that, in part 2, we're going to go through some case studies, look at some development of the law on LAD. I'm sure some of you may have heard some of the cases of, PJD Regency, Ming, Blue Dream, Cubic, these are the popular cases, which deals with LAD, in terms of when you calculate your deadline to deliver your vacant possession, whether, you have to show actual loss in claiming for LAD. We will go through them briefly, just so you know what are your rights as a home buyer and maybe even developer or contractor. Then lastly, I'm going to, just give you an application of the law to your factual situation. As a layman, when you buy a house, you sign an SPA. For those who is diligent, you may read your SPA from back to front, top to bottom. But I'm sure some of you don't even have the time to go through your SPA, especially when you have lawyers advising you. I don't think one will go through. Of course, my advice is you should go through your SPA or should go through whatever you sign. But oftentimes, I know the reality is many people don't. So I have friends asking me, say, hey, Chee Weng, I've signed this SPA a few years ago, but it's been some time and I haven't gotten my key. What are my rights? Can I claim for whatever damages, for whatever delay? When is the deadline for the developer to give me my key? That's when you need to know. That's when your rights in the SPA is important. You need to know when you're supposed to get the house. And if you do not get the house, what are your rights? So these are the three topics that we will cover today. Now, moving on to the first one. What is LAD? Liquidated ascertained damages. It can also be, there's a lot of different ways to call it. Liquidated ascertained damages is only one of the ways. You may even call it late delivery charges. There's a lot of different terms you can call it. But the net effect is where you have a contractually ascertained or predetermined sum that is claimable by either party in the event of a breach of contract. Now, I know this is a bit legalistic and there's a lot of jargons, So in simplistic term, you may ask me, okay, I don't quite understand. Can you simplify it for me? Well, essentially, it is an agreement between the parties, you and party A, that in the event that the party A cannot fulfill their promise, in the event that party A breached the contract, we have both agreed that party A is going to pay me an X amount. And the X amount can be at a daily rate. For example, if you're a home buyer, you have agreed that developer should deliver, give you the keys and VP on a certain date. If the developer fails to give you the vacant possession, there is a breach. Okay. And in the event of the breach, the contract may say that in the event of breach, I'm entitled to claim from the developer a sum, which is your LAD, for each day the developer delay in giving you your VP. So that's just to put it simply, that's essentially what is a LAD. Now, these are some of the some of the features of what is an LAD. The more important one is first is the creature of contract. I asked you earlier, is LAD something as of right? Meaning, even though if I don't sign, I don't agree to anything, I can claim. It's under the law. Now the question is no. The answer is no. It is a creature of contract, meaning it is something that you have to agree. It has to be something in your contract. If it's not in your contract, you cannot claim LAD. But of course, in most of the contract where time is of essence, means timeline is important, you will have LAD. And especially for home buyers who is buying from developer, under the law actually specified that there is a specific form of SPA that you have to sign. If you're buying your house first time from developer, the contract is already provided under the law. You have to use that form of contract. And in that form of contract, there is a LAD clause. And another feature of LAD is usually delay related. Like as I mentioned earlier, you need to have a breach. And usually the breach is delay. For example, coming back to the example of a home buyer, if developer fail to deliver the vacant possession to you within the agreed time, you can claim for an amount which is 10% of your purchase price, 10% per annum of your purchase price at the daily rate from the day that the developer is supposed to give you the keys until the date you actually get the key. And of course, the third feature is usually applicable when it's difficult for you to ascertain your actual loss. What does it mean? What it means is, well, usually, for example, if you get into a car accident, someone damaged your car, you know your losses. Your losses is essentially my cost to repair my car. To repair, it cost me X amount. This is my actual losses. I'm going to claim against you. But what happened in the event of delay? You're supposed to give me the key, but because you don't give me the key, what is my actual losses that I've suffered? Of course, if you're saying that I'm renting a place at the moment, and because of your delay, I cannot move in, so my rental is my actual losses. But oftentimes you may not have that. So which is why parties prefer to pre-agree that, okay, now we agree, if you delay, we estimate this is my losses. And you can claim for these losses. So which is why you have an LAD, usually to cater for a situation where you cannot really know what sort of losses you're going to suffer in the event of a delay. Now I pause here to ask you a question. The fact that it is difficult for you to show your actual loss, does it mean that you don't have to? When you go to court, you say that, look, we have agreed, you're supposed to pay me 1,000 for every day you delay. Now there's 10 days of delay, you must pay me 10,000. Even though I didn't suffer any loss. For example, I'm staying with my parents. I don't have to pay rent. I don't have to pay storage. There's nothing. You just delay. Yeah, but I go on with my life. Does it mean that I can still just claim for this 10,000? So later on during the case study, we will go through some cases which sort of address this point. But for now, I just want you guys to think about it. Now, here's a typical relationship that you have. One is between home buyer and developer. The first arrow you see on the top. And of course, you have between home buyer and developer, you are buying the house from developer. And then there's a relationship between the developer and the contractor, where the developer engages the contractor to build the project, to construct the entire building, Now, for those of you who's familiar with the concept of privity of contract, do bear in mind that just because the contractor is building the property, the project for the end user, ultimately, because the contractor will build it and then developer will sell it, this does not mean that there is a contract between the home buyer and the contractor. Because of privity of contract, the two arrows are separate arrows. Unless you have a separate arrow between the home buyer and contractor, there is what we call no privity of contract. Why this is important is because you may have a situation where the contractor and the developer agree, for example, contractor, I'm going to build this entire project within 27 months. But the developer's contract with the home buyer says, okay, look, home buyers, I'm going to give you my vacant possession within 36 months. Now, the home buyer cannot turn around and say, well, hey, but the contractor has agreed that you're supposed to do it within 27 months. So if you take 36 months, you are delayed. No, that doesn't work like that because of the doctrine of privity of contract. Again, go back to one of the features of LED, it is a creature of contract. You have to look at what is in the contract. If the timeline between home buyer and developer says 36 months, you have to go with 36 months. Just because the developer decided, to agree with the contractor otherwise, as a home buyer, this does not mean that you have a right to insist for a shorter period or for whatever the developer agreed with the contractor. Now, of course, even though there are two separate contracts, there is a common theme between these two contracts, which is time is very important for both. For purchaser and developer, purchaser wants to get your vacant possession, you want to get your key as soon as possible. So the time is very important. For developer and contractor, time is also very important because you need to make sure you complete within time. Because the longer you drag, the more you have to pay your workers, the more you may even have to pay LED to purchasers. So one of the common theme here is there is time that is very important for both. So, which is why in both of these types of contract, there will be LED clause. As far as home buyer is concerned, like I said, under the law actually stipulates that you must adopt certain form of contract, which is your Schedule G, your Schedule H, your Schedule I, and Schedule J. And in this form of contract, you have your LED clause. As far as the developer and contractor is concerned, the law doesn't specify, okay, what sort of form of contract you want to use. It's up to you. You can be bespoke. Bespoke meaning it's something that you draft from scratch. Or there are certain standard forms for parties to choose to adopt. It's not compulsory. It's there. For example, you have your PAM, you have your FIDIC form of contract, you have your CIDB. These are the standard forms of contract which developer and contractor may decide to agree if they want to. Of course, having said that, there are other types of relationship as well, between your contractor with your subcontractor, contractor with your supplier, and home buyer with subsequent purchaser, your sub-sales. There are other relationships as well. But for purposes of today's topic, I'm only going to focus on these two types of relationship. Now, we go on to the LED clause between home buyer and developer. Like I said, you have your statutory form, which is your Schedule G and your Schedule H. What you see on your screen now is a typical LED clause, which says that, look, vacant possession of the property shall be delivered within 24 months from the date of the agreement. So that's the timeline for the developer to deliver the vacant possession, and it's fixed. Later on we can say under what circumstances you can extend the time, but the form says 24 months for Schedule G. And subclause 2 will say, in the event that the developer fails to deliver within 24 months, you can actually claim for liquidated damages at the rate of 10% per annum of the purchase price from the expiry of the period until the date the purchaser take vacant possession. Meaning, if 24 months have passed, developer has not given you the vacant possession, which in layman, your key, then you can claim for LED, calculated per day, from the first day after 24 months until the day you actually got your key, at the rate of 10% per annum. Okay. For those who do not know what's the difference between Schedule G and Schedule H, I, and J, Schedule G is essentially for your landed property where your titles are issued individually, whereas for Schedule H is usually for your, where there's common property where your titles are not individual titles. For example, your condominium and whatever not. So Schedule H similarly, as you see, the LED clause is is similar to Schedule G as well. But the only difference is for Schedule H, we have 36 months. I presume because you have other parts of the, perhaps there's more units to build. Don't ask me why. That's just what the statute specify. It's 36 months, but the rate is still the same. It's still 10%. And so for both Schedule G and Schedule H, in the event that they fail to deliver within the 24 months or 36 months, you can claim for LED. Later, we will, as we go through some of the case study, we will go through, when does this 24 months and 36 months start to calculate, and what happens if developer do not follow, this 24 months, 36 months. Of course, when you read it, it says from 36 months from the date of the agreement or disagreement. So is that the case? I mean, the short answer is no, because there's a recent development on this on this part, but we'll go through it later. So that's for between the home buyer and the developer. So what happened between developer and contractor? Well, as I mentioned, there is no statutory form of contract that you must use. It's up to the parties. You're happy to discuss. You can even adopt standard form. And what I have on the screen is one of the sample, one of the many LED clauses out there. This one is from the PAM contract 2018. Which says that, look, if the contractor fails to complete the work, which is the construction of the project, architect would have to issue a certificate of non-completion, and upon issuance of the CNC, the employer, which is the developer, is entitled to a sum calculated at the rate stated in the appendix as liquidated damages for the period from the completion date to the practical completion. So again, if contractually contractor and developer agreed you're supposed to complete the project within a certain time, and if they don't do it, they can start claiming for a sum of LED from the date of delay until the date that the project is actually completed. So as you will see, there's a few key differences between LED in the contract between home buyer and developer, and between the developer and contractor. First, more importantly, is the rate of LED. For home buyer and for developer, the rate is already fixed. It's 10% per annum of your property purchase price. But as far as developer and contractor is concerned, it's something that you can agree. Some people want a fixed amount, 1 ringgit per day, 10,000 ringgit per day, or 10% of the, contract sum per day. It's up to parties to negotiate. It's up to them to agree. And another difference is between developer and contractor, because there's a lot of flexibility. You have certain clauses like the PAM itself, we set certain prerequisites that you must comply with before you can claim for LED. For example, your issuance of your certificate of non-completion. You have to issue a CNC before you can claim. As far as the Schedule G and Schedule A is concerned, there's no such prerequisite. And another point is also LED between developer and contractor, you can cap it. I've seen a lot of LED clauses where they try to cap the maximum amount of LED that you can claim. Unfortunately, between home buyer and developer, you cannot. I don't think you can cap the LED amount because, like I said, the form of contract has already been specified. You have to use that form of contract. If you want to amend, you have to apply to the housing minister and whatnot. But between developer and contractor, because it's something that you negotiate and something you agree to, you can even have a cap amount. For example, I pay you 1,000 per day up to a limit of 100,000. So these are the few distinguishing factors between LED clauses in your home buyer and developer contract and your contractor and developer contract. Now we move on to some of the case studies to understand, okay, what is the development on the law of LED? I posed a question earlier, when you're claiming for LED, do you need to show actual loss? And when does the 24 months or 36 months starts to count? And more importantly, as a home buyer or as a contractor who is looking to claim for LED, how long do you have, before you need to file a suit? Is there a timeline? For example, if they've been delayed for 4 years Can I still go to court? If they delay for 10 years, can I still go to court? So we'll go through some of the case law to sort of address these questions that you may have as a home buyer, contractor, or even developer. Now, the first case, which is a very interesting case, is the case of PJD Regency. The question here is, when does the period of 24 months and 36 months starts to be calculated? As a matter of background, as many of you know, if you are a home buyer, it is quite a common practice for developer to collect what we call a booking fee. Before you sign any SPA, you go to the showroom, you check out the showroom unit, and then you sit down with the agent. The agent say, look, you only have limited units. Do you want to buy or do you not want to buy? This is a very common tactic. So as a home buyer, you're worried that you lose out on good units. So you say, okay, I want to buy now. I want to book now. So the agent said, no worries, you can chop now. You don't have to commit first. You don't have to sign the SPA first. You pay the booking fee, sign the booking form. If later on you decide not to buy, it's okay. We'll refund this booking fee. It's a very common practice. A lot of developer does it. So now, the question is, the fact is, this act of collecting booking fee is actually illegal or prohibited under the HDA, which is your Housing Development Act. So despite this, it is still a very common practice for developer to still collect booking fees. So in this case of PJD Regency, one of the purchasers try to argue, look, you have collected booking fee. That is when, we have reached an agreement. So if you follow back Schedule G and Schedule H, it says 24 months from the date of the agreement. And the date of agreement is not your SPA date. It should be the booking fee date. That's when, because they are arguing, that's when an agreement has reached. When I pay you the booking fee and I say I want to buy it. So what does the court say? As I mentioned to you, I showed you the clause earlier. It says, 24 months from the date of this agreement, which is your SPA. But purchasers try to argue, no, it's not the date of SPA. It should be booking fee. Of course, it's to the benefit of the purchaser to say you should start counting from booking fee, because you start counting the 24 months earlier, then most likely than not, there will be delay by the developer, and most likely than not, purchaser can and will claim for LAD. So what does the court say? The courts actually found in favor of the purchaser and said that for purposes of calculating LAD under a statutory contract, which is your Schedule G and Schedule H, the period for the delivery of vacant possession starts from the date where the purchaser paid the booking fee and not from the date of this your SPA, sale and purchase agreement. Now, why did the court decide this way? Despite the clear wording of the clause, which says date of this agreement. It doesn't say from the date of booking fee or whatever not. Now, here's the reason why the court have decided, look, it should be from the booking fee. Because one, HDA, which is your Housing Development Act, which states that you have to adopt your Schedule G and Schedule H, is a social legislation. Social legislation means it's meant to protect the weaker parties, in this case, purchasers. Because developer, you have big developers, you have big legal team, you're well-funded. Whereas as a home buyer, you work hard to save up, to buy houses, and usually there's not much bargaining power between you and the developer. The developer would say, well, you take it or leave it. I have 100 or other purchasers who wants to take this unit. Which is why, one, the law stipulate in that case, you have to use this standard form of SPA. And of course, the HDA has certain other provisions which sort of help to protect purchasers as well. And one of the important regulation under the HDA is that it actually prohibits developers from collecting booking fees. But the court said, in this case, the developer has ignored this prohibition. So, since you are bold enough to ignore the prohibition, you must also bear the consequences of the date to deliver vacant possession being calculated from the day of booking fees. This was what moved the court, to say that, well, you shouldn't have collected booking fee. You collected booking fee, so now you should bear the consequences. One of the reasons is, of course, as many of you may know, one of the common practice of developer is they do not date the SPA. You pay your booking fees, and then maybe the SPA is completed, and then you sign the SPA. Some developers do not even date it. Because the moment you date it, then the 24 months or the 36 months starts to count. And as a layman, you do not know, hey, can I insist for them to put a date where I sign? Some of you may not know and may not insist on it. So it gives the developer a very, unfair advantage. It's as if the developer can say, well, I control the time. It's no longer 24 months or 36 months. I can date the date of the SPA whenever. I can collect booking fees way, even before I start constructing the project. I may even take the money and I don't develop the project. So this is why the court have been moved and said, look, no, that's not the right way. It should count from booking fee. And needless to say, after this case, many purchasers have actually gone to court to sue the developer and said, look, there's a delay. And of course, it also changed many developers' approach as well. I have some clients, they stopped collecting booking fees anymore because of this case. Now, then we move on to the next case of Ming Lee. In this case, it is a Schedule H contract, which was signed on May 2012, and it says the deadline to deliver vacant possession is 36 months. So, which is in accordance to Schedule H. But in that case, the developer needed more time. He said 36 months is not sufficient for me to complete the project. So what did they do? In 2014 October, they applied to the housing minister for an extension of time. Under the HDA, there is provision for you to apply to vary some of the terms under your Schedule H. They applied for it, and in November 2015, the housing controller actually granted the extension. So what happened then was, in this case, the purchaser filed a suit against the developer saying that, look, housing controller doesn't have the power to extend delivery of vacant possession. So what did the court say? So the court went through some analysis, they read the provision under the HDA and whatnot, and they found, look, housing controller does not have power to extend timeline. What I mentioned is the HDA, there are provision for you to vary, but it is not by the housing controller. So that's what the court have interpreted the relevant regulation in the HDA and found that, you cannot vary. You must follow your Schedule H. 36 months means 36 months. You cannot, after you sign the contract, you're going to apply and then try to extend it from the housing controller. So again, after this case, many purchasers said, hey, when they look back at the SPA, it doesn't say 36 months, or even it says 36 months. When you prompt the developer says, oh, we've gotten an extension, which is very common as well. A lot of developers, they get extension and whatever not. So many purchasers went to court and said, look, the extension is invalid. You cannot extend. You must follow 36 months. But then there's a case of Blue Dream. In this case, similar facts. Developer applied for extension, from 36 months, they extended to 54 months, I think, and then they applied for another second EOT to 54 months, 56, I believe, or 60, I believe. But the housing controller granted the first EOT, but only granted partially for the second EOT. You need given the developer 54 months as opposed to the 60 that they've applied to. And then the developer appealed to the housing minister for in regards to the second EOT, and the housing minister actually allowed the appeal. Well, of course, then the purchasers, relying on the case of Ming Lee, try to challenge, say, no, you cannot get EOT. It's invalid. You must follow back your Schedule H. Of course, in the High Court, the court actually found in favor of the purchasers. And he actually said that, the second EOT is invalid. And in fact, even the first EOT is invalid. Even though the purchaser did not challenge the first EOT, the court went ahead and said, look, following Ming Lee, first and second EOT is void. You must go back to 36 months. So can you imagine, as a developer, you have 60, you're supposed to have 60 months to develop, and suddenly the court said, no, it's 36 months. So that difference between 60 months to 36 months, there's quite a huge amount of LAD. So of course, as a prudent developer, the developer appealed, and what did the court say? The Court of Appeal said that whilst Ming Lee said that housing controller does not have the power to extend your 36 months, but Ming Lee does not go further to say that Minister of Housing does not have that power, because under the HDA Act, there are certain regulation, certain powers that has been granted to the minister. And what happened in Ang Ming Lee is the developers tried to argue that, wow, this power has been delegated to the housing controller. So even though, the housing controller have granted the EOT, this is valid EOT because under the Act, minister has power to grant the EOT and they have delegated this power to the housing controller. In Ang Ming Lee, the court doesn't agree. They said, no, housing controller cannot extend. But in Blue Dream, the court said, well, in this case, it's slightly different. This EOT is not granted by the housing controller. This EOT is granted by the Minister of Housing. And under the HDA, Minister of Housing has the power to extend the timeline. So since in this case, in Blue Dream, which I think have been recently affirmed in the federal court, since the EOT has been granted by the housing minister and not the housing controller, the EOT here is actually valid. So then the tips now is, if you are a home buyer, you want to know whether you have a right, it's first crucial for you to find out who have actually granted the extension of time. Usually developer will get a letter from the housing ministry, and you have to see who actually signed off the extension and who actually granted your extension. If it's housing controller, of course, arguably you can rely on Ang Ming Lee to say, look, you cannot modify the Schedule H or Schedule G. It must be 24 months, it must be 36 months. But if the extension of time is granted by the minister, unfortunately, with the case of Blue Dream, you can't really sort of challenge the extension. Now, moving on to our fourth case, which is the case of Alpine Return Sdn Bhd against Matthew Ng Hock Sing. In this case, the developer has obtained extension of time from the housing controller. Housing controller, not Ministry of Housing, or not the housing minister, and they obtained it on the September of 2014. Then, after that, the SPA was signed between the purchasers and the developer, Alpine. So it was signed in December 2015. Of course, then the purchaser in this case tried to rely on Ang Ming Lee to say, look, you cannot be 60 months. You have to be 36 months. Your EOT, even though it's granted by the housing controller, this is invalid because of the case of Ang Ming Lee. Now, what did the court found? Now, surprisingly, the court held that, well, EOT granted by housing controller is still invalid. Ang Ming Lee is still good law. But in this case, the purchaser is stopped. Stopped meaning you're stopped or prevented from challenging the SPA because of very crucial distinguishing fact between the case of Alpine and Ang Ming Lee, which is one, the EOT, the extension of time from 36 months to 60 months, in this case was obtained before the SPAs was signed. In Ang Ming Lee, as I've taken you through the facts, the SPA was signed and it says 36 months. It follows the Schedule H. But later on, the developer went and applied and got the extension from the housing controller. So the court said, look, you can't do it. Housing controller cannot grant EOT. But in this case, the extension from housing controller was obtained before the SPA is signed, but this doesn't mean or doesn't make the extension valid. The court said it's still invalid, but because of the fact that when you signed the SPA, you have seen the clause expressly says 60 months. It's not like Ang Ming Lee where the clause said 36 months and after you sign, you go and get an extension. Here, when you sign the SPA, it's already 60 months. So the court say in this situation, it's not fair for you as a home buyer to now insist on 36 months. If you wanted 36 months, you shouldn't have signed the contract. Because when you sign the contract, it actually says 60 months. Of course, I have to also let you know there are differing decisions as well, whereby extension was granted before SPA was signed, but the court said no, you're not stopped. You can still claim. Ang Ming Lee is still good law. But do bear in mind there are some cases which says that, well, when you sign, is already not 36 months. This is not fair for you to now want to come back and say, no, I want 36 months. Of course, this point I believe is still being appealed in the federal court. It's still a very fluid point. Hopefully, the federal court will give some clarity on this point on whether the fact that you got the EOT before SPA was signed, is it a big factor, on whether purchasers can claim for LAD. So this is a part of the judgment in Alpine Return, where they say, where there was modifications such as the extension was secured prior to the execution of the contract of sale under Schedule H with the purchaser, there is no concern about the need to ensure protection of purchaser in the SPA. The doctrine of estoppel by contract will apply to prevent defendant from denying terms, as contained in the SPA. So another point the court has also moved is the need to protect purchaser does not arise. In unwillingly, yes, I need to protect purchasers because as a developer, you cannot take advantage of the weaker power of the purchaser and unilaterally go and seek for extension. But here there's no such need because when you sign purchases, you can read it, you can choose not to wait for 60 months or choose not to wait for 48 months. But the fact that you sign, you knew and you're prepared to wait for it. So because of this, the court said, look, it's not fair. You are stopped from insisting that it should be 36 months. Now, moving on to my fifth case, which is the case of Obata-Ambak Holdings Sdn Bhd and Prima. So I'm going to take you to some of the facts, which is, SPA was signed in July 2012, and the SPA state that the date to deliver vacant possession is 54 months, which is already not in accordance to your Schedule H. So of course, then the purchaser tried to argue and tried to challenge and said, look, you cannot amend from 36 months to 54 months. This SPA is in breach of the Schedule H. And in June 2020, the purchaser filed a suit. Now, what is interesting to note here is one of the points that was raised by the developer is the issue of limitation. What is limitation? Well, under the law, in the event that you have a breach of contract, of course, this doesn't apply to just your purchaser and developer contract. It can be any breach of contract. Your supply of goods can be a breach of contract as well. Under the law, it actually says you have a period of 6 years from when the cause of action accrue for you to file a suit. In simplistic terms, if I breach my contract with you today, you have 6 years from today to bring me to court. If you only bring me to court 6 years plus 1 day after the 6 years, you cannot claim. It is under the law that your claim will be struck out. So in this case, what the developer is trying to argue is the SPA was signed in 2012. You have only filed the suit in 2020, which is 8 years, almost about 8 years. And because of this, the issue of limitation kicks in. Of course, the purchaser then, counter-argue to say, no, my cause of action does not happen when I sign the SPA. My cause of action happened when you actually give me the key. Because when you actually give me the key, that's when I know how much you have delayed. If I calculate from 36 months, you have only given me on the 55 or 56 months, there is the delay. And that's when the breach happened. And that's when the 6 years for me to bring it to court starts. So what did the court find? The court actually found that, look, in this case, you as a purchaser, you are challenging the validity of the clause because the clause say, as opposed to 36 months, you have 54 months, which you say as a purchaser is in breach of Schedule H. So when the developer modifies Schedule H, there is already a breach. And when does the breach happen? When you actually sign the SPA. Because when you sign, it's actually in breach of Schedule H. And because of this, your cause of action runs from the date of execution of the SPA. And because of this, 6 years have passed in 2018. And since you have filed the suit in 2020, limitations have already set in and the purchasers cannot claim for LAD. And this decision of Obata has been affirmed in the Court of Appeal. I'm not sure if it's going to federal court, but this is the position of law. So as the purchasers, you need to be prudent. If you are thinking of taking an action against developers, you need to be prudent and be aware of this timeline of 6 years. Now, earlier I put a question to all of you. Just because it's difficult for me to, determine what are the losses I've suffered because of the delay, does it mean that I don't have to show what are my losses? Now, the case of Selva Kuma and Joel Costa, which is quite an old case, actually says that no, despite the contract saying that, look, this is the amount that I'm going to pay you in the event of a breach, you still have to show actual loss. You still have to show, okay, what actual losses have I suffered because of your delay. You cannot say, well, the contract agree, you must pay me means you must pay me. I don't have to show you what's my actual loss. No, the federal court in Johor Coastal and South Coastal, no, if you want to claim for LAD, you still have to prove. You have to establish there's a breach. You have to show that you have suffered actual losses. Then only you can claim. And this is despite, of course, there's an exception. Exception is where there's no known measure of assessing the loss. Unless it's very difficult, there's no way for me to calculate what is my losses. Then in that case, you don't have to show actual losses. And this is despite the wording of Section 75 of the Contracts Act. We sort of, deal specifically with LAD. We says that when a contract has been breached, and if a sum is named in the contract, which is in your typical LAD clause, the party complaining of the breach is entitled whether or not actual damage or loss is proved, to a reasonable compensation not exceeding the amount so named. So Section 75 actually says you don't have to show actual loss. You don't have to show actual damage. But despite this, the federal court in Johor Coastal and Sabah Kumar interpreted Section 75 slightly differently and said that no, you still have to prove actual loss. Now, this is the old position. Now, that in 2018, it's not recent anymore. I used to keep calling it recent because, this was quite a groundbreaking decision. Cubic was in 2018. It's another federal court decision. They've actually revised and revisited the position of Johor Coastal. It actually says that now, look, the situation has changed. You do not need to prove actual loss anymore. Instead, if you want to claim for LAD, all you need to show is there is a breach of the contract and there is a LAD clause. And once you have established that, the burden then shifts on the party who have breached to show that, look, your LAD claim is unreasonable or your LAD clause is unreasonable. So this, what I've shown on the screen is the extract of the judgment, but to put it simply, in a simple manner, the conclusion of Cubic is you don't need to prove actual loss. You only need to prove there's a breach. And once breach, is for the other party to show that the clause is unreasonable or the LAD sum is unreasonable. But the federal court went on to say that, look, that doesn't mean that you don't have to show actual loss at all. Actual loss is still relevant. It's still a useful starting point. Proof of actual loss is not the sole conclusion determinant of reasonable compensation, although evidence of the same may be a useful starting point. So with Cubic, you do no longer need to show that, oh, look, because of your delay, I suffered XXXX losses. But it's still a useful starting point. Now, so having taken you through the decision of PJD Regency, you start calculating from your booking form, and also the case of Obata, 6 years where you have to file your suit. How do you apply that factually, for some of the laymen who don't understand the legalistic term? What is it in a nutshell? Well, in a nutshell, it is this. Pre-PJD Regency, you can see the booking fee date. I'm just giving an example. Booking fee date is 1st of April 2021. SPA date is May 2021. You sign the SPA one month later. So when does the 36 months happen? Before PJD Regency, one may argue it should be 36 months from the date of the SPA. So it will be 30th April 2024, which is 3 years from the date of SPA. Now, after post PJD Regency, of course, that changed. It's no longer 30th of April 2024. Instead, it is 31st of March 2024, because the 36 months starts from the date of your booking fee. Now, as far as Obata is concerned, this is on the question of when you need to, file an action. Obata says it should be 6 years from the date your SPA is signed. So if you sign your SPA in the 1st of May 2021, the last day for you to file your action is 6 years from then, which is 31st April 2027. But one thing to bear in mind is this is only if the extension of time, there's no extension of time granted by the minister. Meaning to say, if when you sign the SPA actually said 36 months, you cannot file any suit because, the 6 months does not start because 36 months is still correct unless they delay in the 36 months, then your cause of action would have accrued at a different date. But if when you sign the contract, it already is not in compliance with Schedule H or your Schedule G, it doesn't say 24 months or 36 months, it says 14 months, 50 months, and you found out that this is because of an extension granted by the housing controller, or if there's no extension granted by anyone, but the developer for some reason decided to just put 40 months, 50 months, your cause of action actually accrues when you sign the SPA. So that you need to bear in mind. And your 6 years already start from there. You need to make sure that any action you file is before the expiry of 6 months from the date of your SPA. Now, so in a nutshell, what are the things that you need to take note of? Okay, but sorry, before that, another point to also note is, which I've not gone through because due to the lack of time, there is this COVID-19 Act, which was passed in October last year, 2020, I think, where there are certain time period which has been excluded from the calculation of these 36 months and 24 months. I believe it's from the 18th of March 2020 to 31st of March 2020. So those period has been exempted, meaning to say if during that period the 26 months should not be calculated into it, because the government and the parliament actually understand that, look, because of COVID, developer cannot even construct, so it's not fair to include those period. At the same time, the law is fair as well. You also say that if as a purchaser you couldn't make your payment for your property during that period, there will not be any late payment interest. And at the same time, I think in the event that there's a defect liability period, those periods are excluded as well. But that's a topic for another day on COVID-19, on how it has been exempted and all this. So just so you for you all to bear in mind. So at the end of the day, these are some of the practical tips that I can give if you're contemplating whether to claim for LAD. Number one, you need to ensure that it's an LAD clause. As I said, LAD is a creature of contract. If it's not in your contract, you cannot claim. Of course, if you're adopting the Schedule G, Schedule H, Schedule I, Schedule J, there is a LAD clause that is there. But even if you have a statutory contract and you have an LAD clause, you need to make sure that the timeline as in the SPA is as per what is in the form, 24 months and 36 months. And two, you need to make sure that the LAD sum is reasonable because of the case of cubic, and in determining whether the LAD clause is reasonable, perhaps you can sort of estimate some of the foreseeable losses you have in the event of delay, such as your loss of rent, your loss of income, storage costs, because you delay, you don't give me the house, I have to store my furniture somewhere else, any fines that you have to pay third party, any financing costs, I've taken loan, because of the delay, I have to pay extra interest. So you maybe can factor all these to come to a estimate on whether it's reasonable. Of course, like I mentioned, if it's Schedule G and Schedule H, the rates are already stipulated. There is actually no need for you to decide what is the quantum, but it's more applicable for maybe your sub-sale or even for between developer and contractor. And of course, in the event of any doubt, please seek legal advice to sort of, to advise you on one, whether you can claim for LAD, whether you can challenge the extension of time, and when is the later date for you to file your action. Please do seek legal advice. So yes, that's that. So just a bit of a background about myself for those who's interested. I'm a lawyer, a partner with the Leong Chee Co, who specializes in construction. So I represent various clients from developer, contractors, and purchasers. For various claims, including LAD being one of it, defects, work done. I think that's all for today. Thank you again, once again, everyone, for staying on. I hope you all learned a bit stuff about LAD. And if you have any question, please feel free to ask me. Yep.
All right. Thank you so much, Mr. Chee, for that insightful talk, as well as all the comprehensive case studies we had today. We have now reached the Q&A segment, where Mr. Chee will hopefully clarify any doubts you have on today's topic. So for the first question, we have a question from Miss Nazliana. What are the LED changes made that affect home buyers in 2022 or 2023?
So I think I've briefly taken it through from some of the case studies, which is, nowadays LAD, you don't have to prove actual loss anymore. But the timeline to calculate LAD is now from booking fee. So a lot of purchasers can actually claim for more LAD. That's one, changes from the date of how you calculate the 36 months. And two, on who has the power to extend the timeline under your statutory contract, which is now the Minister of Housing. It's no longer Housing Controller. So we think these are few of the key changes which affect you as home buyer in a good way, because now you may be able to claim more for more LAD.
All right. So moving on, we have a question from Mr. Nicholas Chong. What can be included in liquidated damages?
What can be? I presume you mean what are the losses that you can include in the liquidated damages? Well,
I
first of
believe so.
Yeah. So in LAD, right? If you have agreed to a pre-agreed sum that this is the amount, arguably you can only claim for this amount. You cannot exceed. So, for example, like I mentioned, loss of rental or even finance costs and storage costs and all this. If you have those actual losses, right, and those actual losses actually exceed your LAD, right, one may argue that at best you can only claim for your LAD amount because that is the agreed amount. Of course, if it's lower, you may say, I still want to claim for the LAD amount. So what can include is what I mentioned, your loss of rental, I know your payment of rental, loss of income, and your storage costs and all this.
All right. Moving on, sir, we have a question from Tan Lei. Hi, sir. COVID AOT maximum is 26 months.
For COVID EOT, like I've mentioned, the COVID Act actually excluded some period from the calculation. That I think is not 24 months, it's only about 100 plus days. That is as of right. But developer has the option to apply to the minister to extend that period. And at the moment, there is no maximum that is provided under the law. Of course, when the minister apply, when the developer apply, they have to justify it's due to COVID.
Moving on, we have a question from Miss Shikin Shahrul. What are the major causes of liquidated damage and how are they determined?
Major causes, I think one of the main causes is breach. Only if you breach, you have to pay liquidated damages, and usually the breach here is delay. And there are various reasons why things are delayed. Out of 10 construction projects, I think 10 will be delayed. It may be because of supply issue. It may be because of material. Of course, with COVID, a lot of materials the costs have increased, labor have increased, and because of this, people are taking more time. Developer needing more time to complete the project, and there will be delay. And because of that, there will be dispute.
Super, sir. We have another question from Mr. Calvin Chung Sanfu. Hi, Chee Weng. Thank you for your brief explanation. Can you tell us how to calculate of LED for a main parcel and common property? If the common property is delayed for 6 months, what is the percentage?
I see. Hi, Kevin. Thank you for the question. Yeah, one thing to also note, which Kevin have correctly raised, is that under your Schedule H, there is actually a difference between the timeline to deliver your common property and also the timeline to deliver your units. Both of them have different timeline. Of course, in the event of delay of both, you can claim for LAD for both. But the only difference is under your units, the rates is different. The rates, as I mentioned to you, is 10% of the purchase price. But as for the common property, the rates is slightly lower. I couldn't remember what is the rate, but it's slightly lower than 10%. Yeah, if you give me some time, I may be able to pull it up for you. Just see. Let's see. Yes, so it's 10% per annum of the last 20% of your purchase price. So that's slightly different. If it's unit, it's 10% of your purchase price. But if it's for common facilities, it's 10% of 20% of your purchase price. So the rates is slightly different. Of course, this is only for Schedule H contract, meaning you are buying first hand from developer. If it's for sub-sale and whatever not, then the rates might be different because it's up to parties to agree.
All right, awesome, sir. I hope that answered your question, Mr. Kelvin. I believe that was the last question we have for today. We have now actually reached the end of this talk show. With that, I would like to invite all of you to our upcoming CPD seminars in the month of February. We have the Digital Marketing Masterclass, and on the 23rd, we have the Strata Tribunal CPD seminar, as well as the Property Sales Warriors Strategies seminar on the 28th of February. If you are interested to find out more on these courses, you may visit our Facebook page, which is Excel Academy of Real Estate, as well as contact one of those phone numbers down there. All right. Once again, I would like to thank Mr. Chee Weng for today's talk and sharing his insights on today's topics, as well as all the participants for tuning in today. Thank you so much. We hope to see you in the next one.
Thanks.
You, sir.
Thank you, Naufa, for hosting. And once again, thank you, Excel Academy, for the invitation. And wishing everyone celebrating a happy Chinese New Year. And for those who are still on holiday, happy holidays. See you guys. Thanks, Naufa. Bye.